Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. With me today is attorney Kim Ciesinski, and she's involved in the practice of alternative divorce resolution. She's an attorney who concentrates in resolving divorces and family law issues with a collaborative approach. And Kim, you were here a few months ago and you spoke about a collaborative approach in divorce, and today I'd like to focus on just the child custody process. Why is collaborative divorce a win-win for all when it comes to the child custody process or those issues?
Well, first, thank you for having me, Ken. It's a pleasure to be back. Collaborative divorce is a team approach to the issue of divorce and all of the issues that are relevant to that process. It is completely non-adversarial. The team consists of two attorneys who act as teammates and not adversaries. There is a psychologist who serves in the role of family specialist and coach. And there is a financial advisor that helps us analyze equitable distribution scenarios for tax impacting and things of that nature, pension planning. So the team exists for the sole purpose of helping the family restructure themselves from a nuclear to a binuclear family in a non-adversarial, completely private setting, with the appropriate professionals there to assist them with these issues. It's my opinion that a divorce is a family issue. It's a psychological event, a family issue, and it has legal implications. Our legal system treats it as a legal event, which has some psychological implications, but the system's not equipped to deal with those issues. So our system is designed to, in a divorce proceeding, to dismantle the family, dismantle the roles financially, legally, parentally. And that's the job, that's the function of our system. And it does that. The problem, in my opinion, is that it leaves a void. Once that family is dismantled, there have not been any steps taken to create a new foundation, a new ability for the parents to recreate their roles to one another and their relationships to one another, either parentally, financially, or emotionally. So the collaborative process fills that need, and it fills that need quite beautifully in regard to the issue of custody. Custody is one of the most contentious issues you can possibly experience in the context of a divorce proceeding. As you can imagine, anything that deals with your children is a very emotional topic. When you leave that issue to the court system, in essence, what you're doing is you're relinquishing control of all decision-making regarding how your children will be raised, who will they live with, how will they be supported. And if you think about it, that's a rather odd thing to do. When you're litigating in a custody case, you're literally turning over the decision-making and you're substituting your judgment for the judgment of a judge who is only there to apply the law and maybe a very compassionate person, but quite frankly doesn't love your children like you do. So that relinquishment of control leads to tremendous anxiety and tremendous issues when trying to reestablish your roles to one another as co-parents. In the collaborative process, we have a psychologist on the team who is a family specialist and works with the couple to put them in control of the decisions that have to be made regarding whose home the children will live in, how their financial and their emotional needs will be met. And this is done, the psychologist, the appropriate professional to deal with this issue, not a judge, and not an attorney assigned to act as counsel for the children. So the process results in a much more positive outcome, and I'm finding that it helps people to move forward in a more constructive and positive way. I feel that the family is the foundation of our society, and I think that the way we handle the issue of divorce within our legal system is inimical to the ability to raise healthy, well-adjusted adults that can move forward in life and have healthy relationships to one another.
And aside from the issues between the parents, and I should have mentioned earlier that you're also a co-author or contributor to the book Stress-Free Divorce, Volume 3. And it sounds like from what you're saying, you are also making that divorce less stressful to all concerned.
Absolutely.
So, and this is because it's a less stressful divorce. Aside from the parties, the husband and wife, the children are going to be less stressed about it before, during, and after.
Yes, and that leads to a much more successful future for the family.
And in the traditional adversarial system, really the parties sometimes beat up on one another or negate their parenting abilities because that's what they believe or that's what they think will give them leverage.
Well, that's how the system is structured. There has to be a winner. There has to be a loser. And battle lines get drawn. And any distrust that exists within the context of the couple or the family is only exasperated by the procedures and the techniques by which our courts go about deciding the issue of custody and parenting. There's nothing more stressful than going through a custody.
And usually the judge isn't Solomonian. Of course, they're not going to do anything drastic like splitting the child. So what are some of the approaches, the collaborative approaches? If the parties are going to embark on a win-win situation, traditionally sometimes there's a notion or goal one party or the other is for total physical custody. So what are some of the collaborative approaches that can reach that win-win solution?
Well, the beauty of the collaborative process with regard to the issue of parenting is the two parties, the two spouses, can create any scenario they want. It's really all about out-of-the-box thinking. So, to give an example, when you go through a custody battle, a litigated custody battle, a typical parenting plan will be the children reside with one party, the primary custodial parent, and they have parenting time with the other parent. And the typical parenting plan is every other weekend and one night during the week for dinner. There's no typical in the collaborative process. It can be anything that you want it to be. And that's a tremendous advantage, because when it's imposed upon the family, this is how you're going to raise your children, this is where they're going to live, this is how often the other parent will get to see, that's such an unhealthy it's an unhealtty solution.
And it becomes contentious as it goes on.
Very contentious.
And tit for tat, and sometimes tremendous litigation around holidays or around a lack of flexibility.
Yes. It doesn't. Our system does nothing to engender flexibility or cooperation between the people. It's designed to draw lines and separate people. And there has to be a winner and a loser. And when it comes to children and raising children, there shouldn't be a winner and a loser. Everybody should win.
And aside from the parties and being able to co-parent in the future, it's going to leave the children better off. Absolutely.
When you take down that stress level and you reduce the noise, children are not deprived of their sense of security. They're not put in that position where they feel like if they show love to one parent, they are betraying the other parent.
Or have to make a choice, about support for one parent over the other.
Yes.
And so what are, just if you can give us a few examples, you mentioned the typical scenario, but under a collaborative process, what type of different kind of arrangements could there be?
Well, I've handled a case, and this is a pretty typical arrangement. They are going to have their children go back and forth between their homes. They've agreed to live on the same street. And the children, with some basic guidelines of time, but they have agreed that they're going to live in close proximity to one another, and the children are going to be free to come back and forth between the homes. They've made plans for a wardrobe in both places so that the children don't have to perpetually carry their belongings back and forth between the homes. That's stressful for a child. So they're going to create 2 home bases. The court can't do that, but 2 parents who want to do the best for their kids certainly can.
In fact, the court won't even impose some type of shared custody, even if it's not that complete.
Correct. Yeah. One person has to be deemed the sole residential parent.
To the loss of the other.
Yes.
So someone could share, like a very flexible sharing arrangement like you described, or they could split the weeks, or they could, alternate weeks. There could be a lot of different scenarios.
Again, that's the beauty of the process. It can be anything that they want it to be.
And it can evolve or try other ideas as time goes on. Because a person doesn't have to draw a line in the sand or be afraid to give in to something because it becomes bad precedent.
That's a very good point. You remove the fear of, if I'm cooperative on this point, then I'm going to get hurt on another issue. There's no fear of that.
Or if you're given, even on that issue, if you're given for the moment, you're afraid it might be used against you.
Exactly. There's no fear of that.
And does the psychologist as part of your team meet with the children to find out, what their situation is and just try to help counsel them through the process as well?
Yes. Yeah, on occasion, particularly if the children are older. The family specialist will not only meet with the parents, but meet with the children. And it's not like in the court system where they're meeting with the children to get a sense of who they want to live with or, which parent's the better parent. That's not the purpose. The purpose of meeting with the children is to understand their needs better and then to help the parents, to guide the parents, to come to an arrangement that's going to meet the needs, the developmental and the psychological needs of the children. And
these needs may change as a child gets older or changes their activities or something along those lines.
That's another benefit. The process is fluid, and there's always opportunity for future modifications without having to commence post-judgment litigation.
And what about temporary issues? Just while you're looking at a global agreement, do you have some starting point?
Yes, absolutely. The very first meeting of the team, the first time we assemble, we address immediate issues. And often the immediate issue is, well, maybe somebody's going to move out or someone's not going to move out. How are we going to take care of the children together in a manner that decreases the stress for them and provides them with that continued sense of security that both of their parents love them and that their parents aren't killing each other.
Okay, we're going to come back in a moment. We have some more issues and maybe you can give us some more examples of situations you've been involved with. Our guest is attorney Kim Ciesinski. She is in the field of collaborative divorce and is involved in alternate divorce resolution. And as you've heard, she's also a contributor to the book, The Stress-Free Divorce, Volume 3. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. And we'll be back in a moment.
This program is brought to you by Nassau Community College, which offers a paralegal studies program. Students can major in paralegal studies while earning their associate's degree, or earn a paralegal certificate if they already have a college degree. These programs can even help you start a second career as a paralegal. It's a program for anyone who wants to work in a law office assisting lawyers, the government, or a position in an insurance company. More information about full-time, part-time, days, evenings, weekends, or online courses is available by calling 516-572-7774 or by email at paralegal@ncc.edu.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking with attorney Kim Ciesinski, and we're talking about collaborative divorce in the child custody process, which is a big part of it.